I'm George Gay, and I'd like to talk to you a little bit about two facets or aspects of a prosecution, a criminal prosecution for the commission of a computer crime. One has to relate to the concept of evidence. That is, information that criminal prosecution will use to be able to make a valid case before the court to secure the conviction of the defendant. Evidence is not all information relating to the offense, but a specific type of information. Of course, it does have to relate to the offense, so it has to have some connection, meaningful, to the alleged crime. But there's a second filter or layer of consideration with evidence, and that is going to be how well it helps to establish the guilt or a finding of guilty or not guilty for the defendant. There are various rules, and in many instances, the federal government's approach towards these kinds of rules have been upheld and duplicated on the state level. Think about the ways in which evidence becomes an issue. For one, what is the issue presented to criminal prosecution when it comes down to the evidence that's seized at the scene of an alleged crime and its use in a trial? This relates to the somewhat familiar evidentiary concept of chain of custody. The concern here is that in the transmission of data from one place to the next, or items from one place to the next, and ultimately before the court, that opportunities for tampering could arise. So chain of custody relates to these specific steps taken to be able to get the items before the court. There are other types of issues relating to evidence, including how do you end up preserving it, and the issue of hearsay, a topic that is at least worth much deeper exploration than what could be seen in a typical computer crimes class. There's another facet or aspect to criminal prosecution to consider, and that is the use of legal procedures to be able to seize a particular computer, for example. I'm talking about search and seizures, specifically searches, and issues relating to the Fourth Amendment and the use of the Fourth Amendment to state prosecutions via the 14th Amendment. Quite literally, government should not arbitrarily be able to take or search items of individuals. This is something that is made fairly clear in the Fourth Amendment, but it's also clear that it's possible to do so for use in a criminal prosecution so long as certain procedures are followed. And as a result, most people know about warrants and search warrants, that as a general rule, you need to be able to go before a magistrate or a judge and through the use of an affidavit, allege certain facts that could establish that a crime has been committed and therefore that a search is needed to be able to delve more deeply into that issue. There can be instances when it's not feasible to be able to get a warrant, but in general, those are supposed to be discouraged so long as an opportunity to get a warrant exists. But issues related to warrants get fairly complicated and would require an entire course to explore in greater depth. Nonetheless, like with the taking of any kind of information or item, which could be used in a subsequent prosecution, criminal prosecutors and law enforcement, of course, will need to be able to abide by these standards and rules so as to be able to use the information or item secured as part of the prosecution. Thanks, then.